So let's get to what we're here for. I am going to introduce the Latin American IP SME Help Desk, which is a service from the European Union, from the European Commission, to a small and medium-sized business established in the single market zone. That includes all the European Union member states, the Balkans, Turkey, Ukraine, and I'm probably missing some of the countries, but all of these small and medium-sized companies of that territory can be beneficiary of our services, which are free of charge, confidential, and business-oriented. We have a first line of assistance where we help you position yourself in what intellectual property is for your business in Latin America. But we have also sister projects in India, China, Southeast Asia, Africa that do the same services, but with a different geographical scope. So as I was saying, our main and most important service for you, I think, is the helpline, in which the helpline and the book a meeting with a expert. You can have a meeting with one of experts in your preferred language, English, Spanish, German, French, or Portuguese. And we aim to solve your queries within 3 working days without any charge. As I said, we cannot represent you before the office or before a negotiation, but we can help you position yourself where you are, understand your situation, and how to solve any issues you may have in the region. The other main services we provide is the training, like the one we have today. And we have many trainings, many trainings. Sometimes our trainings are generalistic. We focus on the whole region. Sometimes our trainings are more focused on specific countries or specific sectors. We can focus on software sector, or on health tech, or engineering, or mobility. It depends. The training here we can tailor-made to the needs of our partners. And again, our trainings are free of charge, business oriented, and we try to keep it very free of legal jargon. We also have in our website country guides, fact sheets, news and events, case studies, which I think bring a lot of the case studies bring a lot of inspiration and understanding of what companies are seeing when they're landing in the territory, you know? So, like I said, we are 6 help desks. Each of the help desks have a different geographical scope, but we also have the same services. In our agenda today, we're going to have a brief overview. We're going to talk about trademarks. We're going to talk about patents, designs, a few of the challenges and the solutions you can find to solve those challenges. And at the end, you can ask me anything, and I'm going to try to answer on the spot. So to begin with, I always like to center our thoughts into what are we doing here, and what ideally what we're going to be doing in the territory of destination. That's trade. We are trading something for money. I don't care what it is, what you're trading. You can be trading a software, we could be trading a banana, you can be trade anything, but you selling something for exchanging something for money. So here I say trade is black and white. It's simple. It's like going to the market to get your fruits and vegetables. You give some money, you get your vegetables back. Intellectual property rights are the color in trade. And here I'll explain why they are the color in trade. because they give you a differentiating factor and uniqueness factor that it gives you elements to stand out in front of your consumer. And here, the example I bring to you could not be any clearer, and I think is very easy to understand. Fruits and vegetables, in this case, particular bananas, are a product made by nature that traditionally has been traded as a commodity, is always purchased by the kilo, and rarely it has been traded with intellectual property. However, we have seen a revolution in the sector trade, and I bring this example. This revolution is so obvious and is so evident in a very traditional sector that you have to translate it to your own sector, which is probably a lot more sophisticated than this one. So fruits and vegetables are now start being traded with trademarks. You see, if you go to a supermarket, your apples, your bananas, your oranges, they all come with a sticker. That's not casualty. That's not just an accident. This is because you're trying to get to your consumer and give them a little additional an additional factor for them to make their choice. So that's what intellectual property do. It helps your consumer to make their choice. And here you see banana is not banana. Banana is chiquita banana. You see the little sticker there. But not only that, in their website, they are giving recipes. And the recipes is a banana bread, but it's not any banana bread. It's chiquita banana bread. The other ingredients are not mentioned with their brand. The only ingredient that has their own brand, a specific brand, a specific banana you're going to look for to make this recipe is the chiquita banana. Okay, so that's what I want you to do for your business. Whatever you're trading, what are you giving the consumer for them to come back and back to you? So intellectual property, as you see, is present everywhere. From very traditional business like the trade of fruits and vegetables to how sophisticated your business is. Hence, not owning an intellectual property is not an option for a business looking for success, especially success in the international market. Now, having said that, we have to understand two main points. One of the main points, when we talk about protection, we're talking about at least three main stages to have it effective and efficient. That is, registration is a step one, use is a step two, and enforcement is a step three. So registration is generally where your right is born, where you gain and you assert the ownership of that right, be that a trademark, be that a brand, be that a technology solution, be that a design, be that an artistic work. Registration is where you assert the ownership and where everything starts. From there, you have to look where profit lies, and that is use. You're going to have to learn how to use those rights you have gained and asserted the ownership to generate ownership, to generate to generate revenue. And the step you don't really want to see, the step you don't really want to be involved with is the third step, which is enforcement. And hopefully you don't have to go through that, but you may. So as you may go through an enforcement stage, which is defending the future of your business, we're going to have to discuss that. And you have to understand the whole thing as a whole to make your moves. So intellectual property rights are territorial, exclusive rights to help monetize certain aspects of an offering. And here I have in color territorial exclusive rights. So we can make a few points. The reason we have different help desk with specific geographic scope, and the reason we talk about Ecuador, Colombia, and Peru is because those rights need to be acquired there where you have a commercial interest. And that's the only reason we need to focus on the geographical scope. Now, another very important aspect of the presentation of today is that Colombia, Ecuador, Peru are members of the Andean community. And that has slightly a bit of impact in intellectual property terms. Meaning that there is an intellectual property regime governed by a community level, making the protection, and here I use the broad term protection, not only registration, but enforcement and use as well, between the member states. Now, apart from Colombia, Ecuador, and Peru, Bolivia is also a member of the Andean community. Now, what exclusive rights we are talking about? What is this exclusive right? Now, if we want to register, if we want to gain exclusive rights to brand identity elements, being that a scent we use for the customers to recognize our offering, be that a sound we use, a logo, a name, that is your trademark. Exclusive rights to brand identity elements. If we considering external aspects of a product or packaging, then we will be talking about exclusive rights to a design. If we're talking about exclusive rights to a technical solution to a problem with industry applicability, that could be a patent. If we're talking about creative exclusive rights to creative works, we need to look for copyright. You see some other rights here. You see traditional knowledge, which is a big thing for the member states of the Andean community. They also exclusive rights to the traditional knowledge. So I don't know what industry or sector you are, but those are especially related to, for example, patterns in textile, and a few other essential traditional trading elements they have in each country, but basically in those countries there is a lot of traditional knowledge. Also domain names, which is not per se an intellectual property, but is highly related to trade, so we have to mention it here. When you're landing, it's not only important to assert the ownership of your trademarks, your designs, your patents, and your copyrights, but also enable the consumer to find you online. And then that's when you also start to understanding the importance of the local extensions of your domain names. Let's say in Colombia, the .co, in Peru, PR, and so on and so forth. So you have to have present the local extensions, country extensions of your domain names, to be present and to make it easy for your customer to find you. Now, What type of exclusive rights we're talking about? We're talking about exclusive rights of, for example, uh, brand identity elements. Okay, to what? Exclusive rights to what? To manufacture the product, or to sell the product, or to license the product, or to import or export the product. And the same thing, exclusive rights to a technical solution, to manufacture it, to sell it, to license, to import, the same thing. These are the exclusive rights you have. Exclusive rights to manufacture, sell, license, import, export. In essence, from making to trading it. Now, with being I've been emphasized this from the beginning of the presentation. These rights are born with registration. So you need to think of the territory you want to land. What are you going to bring with you? What you need to register, where, when, and how. Identifying the relevant assets involves systematically reviewing all aspects of your business to uncover the assets that provides a competitive advantage to your business, that contributes to revenue generation, that represents valuable intangible asset. And so you have to be reviewing, and that is as simple as review what are you going to be offering in the territory of destination, and within that offering in the territory of destinations, what are the aspects you want to have exclusive rights to. So it seems cumbersome, and it may be, but it can be very simple if you start simple. Reveal what you're going to be offering and all the aspects involved. Now, where and how to register. Generally speaking, there are two ways to register intellectual property. One is directly in the National Intellectual Property Office, or through the international mechanisms. Now, not all countries in Latin America have been are signatories to all international agreements that allow them to participate in the international registration system. And here, as you see, when you're talking about PCT, the Patent and Cooperation Treaty, Colombia, Ecuador, and Peru are members, are signatories to the PCT. Therefore, there you are allowed to choose either to go directly to the national office or to use the international system. And the international system, especially for patents, has a lot of advantage because it gives you bigger time frame to validate the business model in the destination territory. If we're talking about trademarks, only Colombia is signatory to the international system. So only in Colombia you'll be able to choose between the international system and the National Intellectual Property Office. And if we're talking about designs, which is the Hague Agreement, none of these countries are member of. So neither Colombia, Ecuador, Peru are member of the Hague Treaty, the Hague Agreement.
This information is very important. We expected that Uruguay or Chile to be part of those international agreements. So,
I apologize here is because I thought we are focused on Colombia, Ecuador, and Peru. There are more members here of this system. The Hague system, only Mexico and Brazil are members. So you have other members. So for designs, Latin America is a very, very diverse territory. But I had in my mind we are focused on these three territories only.
Yes, I see. Because we planned this webinar as a preparation phase for our trade mission in Colombia, Ecuador, and Peru. This is the explanation. Yes.
Okay. So here, in the PCT, Uruguay is not a member of the Argentina is not a member of the PCT, but most other countries are a member. The Madrid system also, we have a few other members of of countries of Latin America that are members. It's not only Colombia in Latin America. We have with Madrid trademarks. We have Brazil. We have Colombia. We have Mexico, Peru. A few other members, a few of other countries are members of the Madrid as well. But as I was focusing here, that's what I wanted to highlight. No. Now, understanding where we can go and how we register with a with a formal with a formal request. I apologize. We file a formal request as we would in the National Office of Romania or the European Intellectual Property Office. We do the same, a formal request either to the National Office or the WIPO. Now,
I have a question, if allow me. So a company, sometimes Romanian companies are registered their trademarks to Alicante. So probably this is one of the first questions in their minds. If I have my trademark registered to Alicante, I am protected in South America.
In Latin America, no, unfortunately not. That's where I started. One of the first slides was intellectual property are territorial rights. So a right that we have assert in the European Union belongs to that territory, to the territory of the European Union. If we want a right in a specific country of Latin America, we need the right to be assert in that country. It works, intellectual property, although it seems because it's an intangible asset, it works in a similar fashion as a real estate property. If you have a house in Madrid, that house is established in Madrid. If you have a house in Paris, that house is established in Paris. If you want a house in Peru, you have to buy a house in Peru. It's a similar fashion. So now, moving a little bit forward, we need to know a little bit of more details, no? So at the beginning I said trademarks are exclusive rights to brand identity elements. If we go to what is the legal definition, is a sign used in commerce to distinguish the products or service of different companies. And we have a few requirements. Being the most important requirements here in the Andean community, the graphic representation. So you need to be able to put this sign you use in commerce in a paper. They have to be available. That is another very important requirement. Availability means that no one has tried to register this right before you. Therefore, what I'm telling you here, that time is of essence. So if you're planning to move forward with your business to Latin America, especially these three countries, Colombia, Ecuador, and Peru, the earlier you file for registration, the better. But here, I have an additional concern I need you to have. As I mentioned, the Andean community has some impact in intellectual property, in what intellectual property rights refers, and that is someone that has a right in either Bolivia, Colombia, Ecuador, or Peru can assert its exclusive rights in one of these other countries. It works as a single territory, let's say. So you will be looking for the registration of your trademark in Peru, but someone in Colombia may use their right in Colombia to refrain you from registering your right. So when you're doing your search for availability, when you're doing your search for availability in these territories, it's advisable that your search include Bolivia, Ecuador, Colombia, and Peru. So you clear the path not only in the territory, but within the broader territory that can cause you a problem. So that is a very, very specific nuance to the Andean community. Availability is essential. So time is of the essence. The earlier you do, the better. But also this aspect in which a valid right in none of these other countries can affect the registration in your destination. The duration is similar. The validity of the right is similar to what we are used to in the European Union as 10 years, renewable indefinitely. You can renew for periods of 10 years forever. So the process you will see in Latin America is similar to the process we have here. We conduct a preliminary search, which is not is not really part of the process, but is, as I said, as trademarks from one of the countries can invalidate your application, preliminary search is sort of essential. After you you clear the path, you file your application. There will be a form examination, a publication of the right, and an opposition period. The opposition period in some places, in some of the countries, are after registration, and in some countries is before registration. In any case, there will be an opposition period. It's generally 30 days in the territory in the territory of the Andean community. And after the registration, you have a clear ownership title. If you choose the international route, which is only possible in this case in Colombia, and here again, I remind you that this training was prepared focusing in the three territories. There are other countries in Latin America that this is also possible. If you have a specific doubt to a different country you have not mentioned in this training, please remember we have the helpline. You can send your query, your question to us, and we will reply very, very, very quickly. So here, the international route requires you to have a base application, either a trademark in Romania or a trademark in the European Union. You make your formal request to the Office of Origin. That will be depending on where your base mark's coming from. If it's Romania, the national office in Romania. If it's in the European Union, the European Union Intellectual Property Office. That office will transmit the request to the World Intellectual Property Organization, and which you also carry a formal examination, and after carrying this examination will transmit your requests to your designated countries. Up to the designation made by the World Intellectual Property Office, we're having an international phase. After that, when we're passing the request to the contracting parties, to the designated office, to the destination office, there will be a national phase in which there will be, as in the national application, a substantial examination and a final decision in the territory. So the process, when it reaches the national phase, the process is the same as a national application. Now, here you can imagine from what I'm saying, the phases the process has, that choosing the international route for register your trademarks will have an impact in time, because we have an international phase and a national phase. So that has a slightly impact on your timing. So we're thinking here the time frame for registration is 12 to 18 months. If you chose the national route, that could be shortened a little bit. Now, the other impact of choosing the international route is, as it's based on a national or European application, whatever comes in the national phase, your trademark in Colombia will be dependent from this base application. So for 5 years, your trademark in Colombia, if you follow the international route, is dependent on your base mark, the base mark that was used for the international application. That means if something happens, if something within this 5 years happened to your base application, if your base application is challenged, let's say it's not a registration yet, is an application for a registration in your local office or the UIPO, if that gets canceled, then your application in Colombia will also be canceled. So that is an important factor to take into account when choosing the international route. Now, let's talk about specificities of countries. A trademark application in Colombia can be filled online by residents and non-residents. There's this digital platform similar to what we have in our home countries and within the European Union. It's important to determine the category of the sign, if it's a word mark, if it's a figurative mark, a shape, color, etc. Again, it's highly advised to perform a search before filing it. The search, my recommendation is that you do, if you find a trademark in any of the Andean community members, is that you do a thorough search within the other members as well.
But I suppose everyone will have a contract with a local lawyer or IP property company to perform those checks.
Advisable is advisable, as is not necessary. Not everybody recommends it. I personally think is highly advisable, and as I personally think is an extra cost. Obviously, you have to take into account. But I think you, as there is a risk involved, the risk that your trademark is opposed, the risk that you're going to have to spend more money to have your trademark registered, it's highly advisable to do it, and to do it not only in the country in the country you're looking to have that right recognized, but also within the other members of the Andean community, because of what I mentioned, they can oppose the mark in the territory you're looking for.
There is an option to make only one registration for Andean community, or we have to visit every country?
No. It's not like our European Union trademark. We don't have an Andean trademark. We have national trademarks. However, our national trademarks can be used as a base to oppose a trademark in other Andean community member. But there is no single trademark for the community. The prosecution of the process, prosecution being the process of registration in Colombia, can take less than 6 months. If we choose the national route directly, remember, if we choose the international route, this time frame, as we have different phases to the application, international phase, national phase, that is in large to 12 to 18 months. In Colombia, you also have an express registration. And if you apply for an express registration, the process will take 3 months. It's also advisable to request express publication. This is an additional step to speed the process. The publication, the impact of the publication is that open the opposition period earlier, and therefore the process is shorter. As for the cost, the filling fee is 300 euros, more or less, for one class. Each additional class is 118 euros. If you want to invoke priority, which is a priority for a right that was filled within the national office of your home country or within the European Union, you have to be aware that you can only invoke that priority within 6 months from the initial application. In Colombia, non-conventional trademarks as 3D trademarks, tactile trademarks, scent can be registered. Packaging, the packaging, for example, can only be protected by unfair competition rules. Packaging cannot be registered as a trademark. In Peru, as well, other non-traditional trademarks such as trademark designs and packagings and scents can be registered. So different from Colombia to Peru is like the packaging can be a trademark. There are some limited rights to owners of unregistered trademark. My recommendation is don't go abroad. Do not go abroad thinking you have rights to an unregistered trademark, because it makes your life harder. It opens you up for certain risks. The risk of somebody registering the right, the risk of somebody using the rights, and you are in a weak position to defend it. So if you're going abroad, registering is essential to avoid any risk. And also important to note that the use of a registered right is mandatory within 3 years from registration. It doesn't mean that the right will be canceled if within the 3 years, but it means that if somebody challenges your right, you would have to provide proof of use, and if you cannot provide proof of use in this process, then the trademark can be canceled. It's not an automatic cancellation; it's a cancellation triggered by a competitor, usually. So it's important to be aware. Coexistent agreements will be allowed and respected as long as they are not misleading for the consumer. So here, in most Latin American countries, consumer defense is highly taken into account. So here you not only, when you consider intellectual property rights, you not only consider the rights you want to gain exclusive rights to, but you also have to consider the consumer and how he's being affected about the rights you want to gain exclusive rights to. Also, in Ecuador, the difference, not differences per se. Ecuador, we require graphic representation, and there will be a 30 days opposition after publication. And that's what we have in terms of trademark, which may seem simple, but is full of details when you go through the process. So if you need our help, please do not hesitate to send us an email with any doubt you may have, because we are here for that. We are here to clear all the doubts you may have in terms of intellectual property in Latin America. Now, moving forward to a patent. A patent is a technical solution to a problem with industry applicability. It can be a product or a process. Now, is the exclusive right, a patent is the exclusive right to that technical solution. The requirements we see in the European Union, be it in our home countries, the member states, or be it at the European level. Requirements are novelty, and novelty is a concept that has to be fulfilled not only in the territory we have a desire for a commercial the commercial establishment, but also worldwide. Novelty, the technical solution we want to have exclusive rights to, has to be new everywhere in the world. There has to be an inventive step. The inventive step being that this solution is not an obvious solution to an expert in the field. Putting two and two together will not be considered inventive. Now, inventive has to be something that will be not obvious for an expert, and has to have industrial applicability. If there's no industrial applicability, this important requirement is not met, and therefore a patent cannot be granted. The duration is exactly the same as we have in the European Union, 20 years. This, in certain cases, can be extended for a few years, but that, again, we have to see individually what has enabled, for example, if the process has taken too long, if the product we are trying to gain the exclusive right is requires an additional administrative authorization, like, for example, pharmaceutical products generally require a health authorization. In this case, if we prove that the process and the authorization has taken a little bit longer than it should, we can request a slight extension of that period. Now, the patent registration can follow two routes. One is the national registration, as in trademarks. We go directly to the national office once our home patent application has reached 12, or before it reaches 12 months for an application date, or we choose the international route through the WIPO. Now here, the process is a little bit longer than a process in trademarks. From 0 to 12 months, we extended it either national or international. From 12 to 18, or from 12 to 16, we have from 12 to 30, we have the international phase. And through the international phase, we actually have different stages. The first stage being the international search report, in which the World Intellectual Property Organization examines those three requirements: novelty, inventive step, and industrial applicability. They analyze in the international phase those three requirements and make make a report. That report is
basically for patents, it takes double time than
yes,
as far as you can see.
yes, because here we also have to have in consideration the office, both national office and the European office and the World Intellectual Property Office. They have limited amount of personnel in specific areas, and each patent goes to a specific area: biologic, chemic, technological, mechanical, etc. So these different patents in different sectors, in different fields, need to be analyzed by and examined by an expert in that field. It cannot be any expert, no. So that's why it takes a little bit longer. Anyway, after it's examined, it's published, and then after it's published, you can enter the national phase in the countries that you have chosen. In this case, we can use the PIST in Colombia, Ecuador, and Peru. In the national phase, although there was an international search and international opinion, the national phase will go through the examination as it would in a national application. Now, the advantage of this process is that it gives you 30 months to validate what you're claiming exclusive rights to. This technical solution you're claiming exclusive right to. This 30 months enables you to see how effective and how beneficial that will be for your business. So all in all, I personally think it's highly advisable to use the international system for patents. Now, again, the office, the national office in Latin America, Colombia, Peru, and Ecuador, function in a similar fashion. They have an online page. You can file the application there. You pay the fees online, etc. Now, prosecution is the fastest in the region. Colombia takes less than 2 years. And the only thing we have to have in mind, and this is for the 3 countries, is that all documentation has to be filled in Spanish. So everything that we have in a home country needs to be translated to Spanish. And that is valid for, obviously, Colombia, Peru, and Ecuador. Now, some particularities of the system. Examination must be in Colombia. Examination must be requested within 6 months from the publication. Otherwise, the application will be considered abandoned. The filling fee is 20 euros. The examination fee, 300 euros. Now, there's an acceleration program, which is called the Patent Prosecution Highway in the region. You can use ProSur, Pacific Islands, Apple, the USPTO, the Andean Community, and the Global Patent Prosecution Highway. This accelerates the process, or it shortens the time frame in which goes from application to a registration or granting. If you have a right in one of these countries, Brazil, Argentina, Chile, or the Pacific Islands, one of the countries of the Pacific Islands, or the United States, or in Apple, if you have a patent that has already been granted there, you can use the granting of these offices to speed up the process in Colombia. In Peru as well. Here in Ecuador, patent is published 12 months after the application. There is a 30 days for opposition after the publication, and examination happens 6 months after publication. And that's all we have to say about patents today. That's not all we have to say, because there's a lot more details we can go into. But time will not allow us today. So we'll move forward into designs. And designs, you need to understand that is the appearance or the shape of industrial product, which confers an ornamental character to that product. And here the requirements are: it has to be new or novel, and novelty again is worldwide. It has to be new everywhere in the world. Certain countries require it to be original. On top of being new, it has to be original. And original is not something that um, is not described in any legislation what original is. So we have to to go through what the jurisprudence, what judges have considered to be original, the description of originality there. Now, another important requirement is that it has to be non-functional. The design or a technical function of the product cannot be what determines this aesthetic feature. If the design is determined by the technical function, we cannot gain exclusive rights to a design. The duration varies depending on the country. Ecuador and Peru is valid for 10 years. Now, I'm going to run through. I want to go through a few of the challenges you may face. And here, again, it's important. FSAD registration is of the essence to assert ownership, and time is of the essence because of the availability requirement. So here this particular challenge we are going to discuss right now, which is a bad faith registration, generally related to trademarks. Here is your weakness. If you decide, oh, I'm going to postpone the registration of my trademark, I start establishing a relationship with someone, and that someone disappeared, and then you realize you register your trademark in the country of your commercial interest in their own name. Now, that's what we call a bad faith registration. There are other variants of what a bad faith registration is, but that is the most common one. So this is your weakness. Look, pay attention not to have the weakness. That weakness is not the country or the system weakness, is your weakness. If you do not take time as an essence for your business, somebody else will consider that. So how do you mitigate that risk? Is strengthen your position through knowledge and through intellectual property registration. Register your trademarks as soon as you decide to go abroad. If this advice is too late, if you're already in a situation of bad faith registration, then there are three possible solutions depending where exactly in moment you are. One is negotiating with the the party that have registered this trademark in bad faith. Negotiate with them for them to transfer the right to you. This can be done if alternative measures have to be taken. Then negotiation is always, I think, is always a pre-step for everything. We have to consider trying amicable means to reach our goals first, and or together with other measures. If we're talking about an application, it's possible that I still have time to have an administrative action before the National Office of Relevance. If it's already registered, then I have possibly to consider judicial action and legal proceedings. Now, with each of these steps, here, what I'm the most, I think it's important to know that if you are in this situation, there is hope. However, this hope comes with headaches. Therefore, that not only with headaches but also with considerable time frame, because if we have a negotiation, administrative solution, and judicial action, they all have a time frame you cannot set a deadline for. You cannot say, let's negotiate and next week this is back into the right course. It doesn't happen like that. If you're already there, you have to be patient because things will take their time. And additionally, apart from the time, you're gonna spend a little money. So there is hope, but hope comes with certain drawbacks. Other things to take in consideration, challenges we see SMEs facing in Latin America, not only in Latin America, but this can be faced in China, Southeast Asia, everywhere in the world. Cultural linguistic barriers or differences. So be aware of the differences in cultural values that can affect the perception of the product service. It may be a color you use in the package, or it may be a detail, an image, or something that local customer will perceive negatively. We make a cultural negative association, or the intended semantic meaning is not what you're looking for, or even a bad translation. So watch out for these cultural and linguistic barriers you may have. Localization is the solution to this challenge. Localization. Challenge we see in terms of use. Maintaining of the rights. Maintaining here we have obligations of use. We've seen that in one of the countries there was an obligation of use within 3 years for trademarks, but also patents. There are certain obligations of use. Otherwise, you may face mandatory licenses, fee payments. If you want to maintain your right, your trademark right or your design right, you need to pay the renewal fee. Or if you want to maintain your patent right, you need to pay the annuity until the term of validity is finished. So every year you have to remember a fee needs to be paid in that specific country. And now also, last but not least, your intellectual property rights have a role in your country contacts. Your intellectual property rights have a role in your non-disclosure agreements. Be clear what kind of information you are giving to the other party and what type of information you don't want to be disclosed. The license agreements you have, intellectual property rights have an impact there. There will be instances where license agreements are only valid if they are registered with the local office. There will be instances where the royalties from the license can only be brought back to Europe if they are registered with the office. The validity of that license can only be, or the term, duration of that license can only be as long as that right exists. So for a trademark, it cannot be a license of a trademark cannot be longer than the validity of that trademark. The same for a patent, etc. Your distribution agreements the same. How do you want your distributor to present your product. How do you want him to use your color schemes, your publicity? Be certain of how you empowering your partner to achieve your goals, and how you want him to use these elements for him and you to reach that goal. So maintaining is a huge challenge. The solution to this challenge is consistency and organization. Use the right as register in the products, packaging, promotional material, invoice, social media. Maintain the records of those use of the registrations of the enforcement actions, and always easily. Now, the last but not least, in terms of the third step, challenges we face defending intellectual property rights in Latin America. The first challenge is detecting the right, and the second challenge is acting in a budget-friendly way. There is a third challenge I am not mentioning here, but is related to patience and the time frame. Because once you detect a problem, solving that problem always take a time. So monitoring the market is important. And monitoring the market means you have to monitor the intellectual property national offices. You have to monitor the domain name register. You have to do sometimes online market watches with searches for mentions, keywords, hashtags, use of your intellectual property rights in social media, marketplaces, search engines. This can be all done manually, or you can hire a service. Obviously, there's always a cost, but this can easily be done manually. Just keep looking what's happening in the market with important all those brand identity elements, but also the keywords you use for your business. And then last but not least, there's an offline market search. And here is you have to always keep your eyes very open for those who try to become your partners, and for some reason it didn't happen. Keep an eye there. What's happening? If you whatever you, I don't know what you're trading, but what is the typical trade chain or trade path for your sector? Keep an eye there. What's happening there? Solution number 2 is register your intellectual property rights with customs where possible. Register your IP with customs to prevent import and export of counterfeit goods if that's where you're trading goods, and provide customs officials. This is not obvious, but officials don't have information. If you only register your rights with them, they don't have enough information to detect what is an infringement and what is not. So they need training. And you need to keep up with all the things you have to do in a business, and that is another one you have to do. And be prepared. The third solution is be prepared to take legal action against infringement and counterfeit. And here, two steps. Pre-litigation is always, like I said, I think it's always beneficial to try to negotiate. Here, in pre-litigation, we have generally a cease and desist letter saying, here, I found you're doing this. I have this right. Please stop. Otherwise, something else. Taking down requests if it's online, if it's a marketplace, etc. And if nothing happens, you have your legal actions, civil and criminal actions. Again, all that comes with time and costs. So be prepared. And last but not least, the last challenge of them all is infringe third-party rights. lack of information on how to avoid claims, actions, and costs for infringement of third-party rights. We always considering I don't want to be copied, but we're not considering I don't want to copy somebody. So that is something I want to bring to attention. This is something not only you, but everyone uh, in your company needs to be aware of this this challenge, because for example, using an image you find online, that image is not necessarily open to public use, especially not open to public commercial use. So if no, your personnel needs to be trained into how to avoid these claims, how to avoid using something that is not yours. The solution here is first making everyone aware. Education and awareness is important. The second is intellectual property rights protect everyone, so trademark searches and freedom to operate searches, that is important. And when you find something you really, really, really want to use and it's not yours, but it's somebody else, seek for authorization. Don't just use it. Seek for an authorization of that party. Hey, I really, really interested in that your trademark, in that your photograph, in that your test, whatever it is you're interested that does not belong to you. Just, hey, I'm really interested. Can you please authorize me to use this within this framework? And see how it goes. So that's all I have to say for you today. Last pieces of advice: know your intellectual property. Keep systematically reviewing your offering to understand what is relevant there. Conduct those searches and register your rights. And keep an eye to see what happens. If you need any additional information per country, per sector, you'll find in our webpage, but you can also contact us with any doubts you may have. Thank you so much for joining me today. I hope you come out with something of value today.
Thank you, Giovanna, for valuable information you provide. For my point of view, it's important that Romanian entrepreneurs to be prepared to go abroad even before embarking in trade missions, like those who organize. So I will try to show now on the screen the 3 target countries we work on to organize those trips. We planned it to have the trip in July, but mostly we will postpone it. But anyway, this training offered by Giovanna Girardi is important step for us to understand better the market and how to prepare our investments there if we'll decide to do it. So I encourage you all to register for any of those 3 trade missions in order to receive more details about our plans for South America. But also, I would like to invite you to have questions for Giovanna if you have some details to clarify or any other ideas. And also, I encourage you to ask for direct meetings for free consultation if you have something to discuss more discreet. And of course, in business, we all are discreet when we have interests there. So if you have any questions, now is the time.
If I may say, I also join you encouraging everyone to join the missions. I think it's incredibly important to go and see for your eyes how the country is, how the people they are. And bear in mind, everyone, absolutely everyone, wants to business and have a good revenue. So It's nice to have the chance to meet with these people that are looking for an opportunity. But having said that, everyone is also looking for an opportunity to be taken care of. So you want an opportunity to make business, and you as the business owner looking to establish yourself abroad, think of how can you enable your future partner. What can you give him to boost that relationship, to help him reach his goals and reach consequently your own goals. Think about how can you support it, and the more you think about how can you support it, the more you'll be able to achieve your goals. That's my last piece of advice.
Yes, it's we can discuss a lot about the business strategy and how to approach a foreign market. There's a lot of things to be learned, and today we made it for only one aspect of this effort. So
Absolutely.
thank you, Giovanna, for sharing us your email address. So and the web page for those who are interested, they can save those links in order to be used in the future when you are interested in the topic. So I have to thank you all for attending this webinar. Thank you, Giovanna. Thank you, Mattia, for helping us. From my point of view, it's a long road to South America, but it's definitely an important aspect for Europe and for Romania, of course, to see beyond the horizon. Thank you all, and see you at the next webinar.
Thank you. Have a good day, everyone.